In light of Trump creating a religious office in the White House targeting anti-Christian bias, I thought I would discuss historical context and origins of the fact that we don't have a state religion. The first clause in the Bill of Rights says Congress shall make no law respecting an establishment of religion. And the Establishment Clause within the First Amendment has roots in early American thought between Thomas Jefferson and Roger Williams. They were trying to separate themselves from the Church of England, which is like a state religion, and the Queen or King, the monarch, is thought to be the head of the church, thanks to Henry VIII. So there is no state religion. So the Establishment Clause within the First Amendment, as I said, has early American roots. There was little contention about it, but America's diversity grew, and so did challenges of old laws and practices. Roger Williams, Rhode Island's founder, proposed a wall or hedge of separation between the secular world and the sacred church in the mid-1600s. Thomas Jefferson famously coined the phrase we all know in his 1802 letter to the Danbury Baptist Association, where he wrote there should be a wall of separation between church and state. Jefferson and James Madison fought to disestablish the Anglican Church in Virginia, arguing that taxpayer support for religion infringed on individual rights. Their stance gained support from dissenting faiths like Baptist, Presbyterians, and Quakers. After World War II, the Supreme Court began interpreting the Establishment Clause more actively. In 1947's Everson versus Board of Education, the court confirmed that the clause extends to state laws via the 14th Amendment. Subsequent cases further defined the concept of separation. The 1971 Lemon v. Kurtzman's case introduced the Lemon test for vetting laws concerning religious establishment. Justice Sandra Day O'Connor later introduced the endorsement test, focusing on whether government actions endorsed religion. Recent cases like Carson v. Macon and Kennedy v. Bremerton School District in 2022 have seen the court move away from the Lemon test, instead referring to historical practices and understandings. These shifts indicate ongoing debates as America's religious diversity continues to grow. The Everson v. Board of Education ruling marked a crucial moment in interpreting the Establishment Clause. The court declared that the clause applied to state laws through the 14th Amendment, solidifying its importance throughout the United States. In Lemon v. Kurtzman, this court established that the Lemon test evaluate laws potentially violating the Establishment Clause. This test required a statute to have a particular purpose, neither advance nor inhibit religion, and not result in excessive government entanglement with religion. The test was later modified in Angstani v. Felton, combining the last two prongs together. Justice Sandra Day O'Connor introduced the endorsement test in Lynch v. Donnelly, proposing that government actions should not endorse or disapprove of religion. This test aimed to ensure that citizens would not feel marginalized due to government acts. The neutrality test emerged from cases involving government funds and religious groups. In Zelman v. Simmons Harris, Ohio's school voucher program was deemed constitutionally permissible as it was neutral concerning religion. Recent cases like Carson v. Macon and Kennedy v. Bremerton School District have marked significant shifts in the court's approach. The rulings moved away from the Lemon test, favoring an understanding based in on historical practices and balancing out prevention of religious establishment with ensuring free exercise rights. Recent Supreme Court rulings have significantly shifted the interpretation of the Establishment Clause, emphasizing historical practices and the interplay between the Establishment and free exercise clauses. There are two perspectives to be had: strict separation advocates and critics of strict separation. The debate extends to practical applications, such as government funding in religious contexts. Zellman v. Simmons-Harris decision upheld a neutral school voucher program. Critics argue this blurs the lines of separation, while supporters say stopping such funding discriminates against religious entities. The ruling in Kennedy v. Bremerton School District supporting a coach's right to pray publicly with students raises questions about religious coercion in public education. Critics argue students may feel pressure to conform, while proponents maintain that preventing the coach from praying would violate his free exercise rights. The differing perspectives highlight the ongoing challenge of balancing religious liberty protection with safeguarding against governmental endorsement of religion. As society becomes more religiously diverse, how might future court decisions further shape this delicate balance? There's no way to tell. So, all that to say, Trump creating religious office in the White House to target anti-Christian bias and support religious liberties is unconstitutional. There shouldn't be any religious anything in the White House. It's meant to be separate and parted away from religious things. And that's not to say that the president himself or herself in the future couldn't have religious faith. It just cannot be part of the decision making from the Oval Office.